Imagine a company registers a trademark in 2018 but never sells a single product under it. Years later, a competitor wants that mark removed to clear their own path. The question is, can they actually force it off the register? And if they try, what exactly do they have to prove? Under Section 47, the answer is yes. This is the use it or lose it rule. If a competitor proves 5 continuous years of non-use, plus a strict 3-month buffer, the mark becomes vulnerable to removal. Trademark registration is not a permanent parking space. The register is an actively policed record of commercial activity. Welcome to Patentworld-ai, Lecture T5. Today we cover the mechanics of cleaning the register, Section 47 Non-Use, Section 57 Rectification, the housekeeping of Sections 58 to 60, and the essential post-2021 jurisdiction rules. Analysis of these sections starts with the Tribunals Reforms Act 2021. As this table shows, the Intellectual Property Appellate Board, IPAB, was abolished and its jurisdiction transferred. The statutory consequence is immediate. Wherever the Act refers to the Appellate Board, read that as High Court. Major jurisdictions have already adapted. The Delhi High Court now operates a dedicated intellectual property division to manage these cases. The Bombay High Court has established its own specialized IP division for the same purpose, and the Madras High Court maintains a similar division to process these rectification and appeal matters. This creates a vital rule for your exam. Today, a rectification or cancellation petition goes to either the Registrar or the High Court. Let's break down the grounds for removal. Section 47, subsection 1, clause A, targets squatter registrations. It applies when a mark was registered without any bona fide intention to use it, and there has been no actual use up to 3 months before the application. The more common ground is Section 47(1)(b), requiring 5 continuous years of non-use from registration. This clock is computed up to 3 months before the application. This buffer stops proprietors from rushing token sales to defeat a cancellation petition. Who can file this? The statute allows a person aggrieved, interpreted liberally to include competitors, or anyone prejudiced by the mark's presence. The registrar can also act on their own initiative. To save the mark, the proprietor must prove bona fide use, meaning genuine commercial trade, like sales, invoices, or exports. Token transactions engineered solely to defeat a petition do not count. The proprietor has 3 primary defenses. First, under Section 48, subsection 2, use by a registered user is legally deemed to be use by the proprietor themselves. Second, Section 47, subsection 2, allows for special circumstances. If non-use was due to external factors like import bans, the mark is protected. However, mere financial difficulty is never a special circumstance. Third, Section 47, subsection 3, offers partial survival. If use is proved for only some goods, the tribunal may limit the registration to those specific items rather than removing the entire mark. In these proceedings, the burden of proof is dynamic. The applicant must first establish a prima facie case of non-use. Once that's done, the burden shifts entirely to the proprietor to prove use or special circumstances. While Section 47 focuses on how a mark is used, Section 57 attacks the foundation of the registration itself. Section 57, subsection 1, allows for cancellation or variation if a proprietor fails to observe a specific condition entered on the register. Subsection 2 provides broad grounds for any person aggrieved by an entry made without sufficient cause, an entry wrongly remaining on the register, or any simple error or defect. Under subsection 4, the tribunal, whether the registrar or the High Court, has the power to rectify the register on its own motion, provided they give notice and a hearing. This is a concurrent jurisdiction. For the exam, remember that petitions are filed on Form TMO with an e-filing fee of 2,700 rupees. The without sufficient cause clause provides the legal basis for these challenges, allowing a petitioner to argue a mark was flawed at its inception. Perhaps it was descriptive, deceptive, or fraudulent, and should never have reached the register in the first place. These validity challenges often emerge during active litigation. When a proprietor files an infringement suit, the defendant typically counters by arguing that the underlying registration itself is invalid. Section 124 manages this conflict. If the invalidity plea is tenable, the infringement suit is stayed pending the rectification outcome. The defendant is given exactly 3 months to apply for rectification at the High Court. If missed, the suit proceeds. This procedural pathway was settled by the Supreme Court in the 2021 case Patel Field Marshal Agencies. This ruling defines Section 124's strategic reality. For a defendant in a high-stakes infringement battle, rectification serves as the standard counterweapon to disarm the registration being used against them. For administrative tasks, use the CAA memory trick: correction, alteration, and adaptation, covering Sections 58, 59, and 60. Section 58 covers correction. This is friendly housekeeping, where the proprietor applies on Form TMP to fix clerical errors or update their own name and address details. Section 59 allows for alteration of the mark itself, but there is a strict limit. It is only permitted if the change does not substantially affect the identity of the trademark. Finally, Section 60 covers adaptation. This allows the registrar to update register entries to match new international classifications of goods, provided they do not extend the proprietor's original rights. Note the statutory pattern here. The Geographical Indications Act copied this housekeeping family verbatim. GI Sections 27, 28, and 29 mirror Trademark Sections 57, 58, and 59. To definitively contrast Section 47 and Section 57, use the UV attack framework. U stands for use, mapping to Section 47. V stands for validity, mapping to Section 57. Compare the core questions. Section 47 attacks use, asking if the mark was neglected. Section 57 attacks validity, asking if the entry was legally flawed from the start. Now compare the timelines. Section 47 relies on a rigid 5-year formula. Section 57 has no fixed limitation. A validity attack can be filed at any time. Despite these differences, they share common traits. Both require a person aggrieved, both use Form TMO, and both can be raised as counterclaims under Section 124. Let's hard-code the facts. Deliver the answer after the pause. Question 1. What is the non-use removal period? 5 continuous years from entry, computed to 3 months before the application. Question 2. Why does the 3-month buffer exist? To disregard panic use rushed in before a petition. Question 3. Whose use saves the proprietor? Any proprietors, including a registered user's deemed use. Question 4. What defines the special circumstances defense? Section 47(2) legal or policy restrictions, not mere business difficulty. Question 5. What are the primary Section 57 rectification grounds? Entry without sufficient cause, wrongly remaining, or error and defect. Question 6. Who holds jurisdiction after 2021? The Registrar or the High Court, because the IPAB is abolished. Question 7. What happens when an infringement defendant challenges validity? A stay of the suit under Section 124. Question 8. When is alteration of a registered mark allowed? Only if identity is not substantially affected, under Section 59. That is T5. Next, in T6, we cover collective and certification marks like ISI, AgMark, and Woolmark. Subscribe to Patentworld.ai and see you there.